but obviously everyone at some point would determine that it's not acceptable for an employee to just not show up to work. So the legal issues that we run into here depend on which laws we could potentially be violating. If we take the example of a point-based attendance system, historically, employers like these on the notion that every time you're absent, it counts as an occurrence. And once you get a certain number of occurrences, you're going to be disciplined and potentially terminated after enough occurrences. And it doesn't matter whether you were sick or had other good reasons for not being here. Under the various statutory leave laws that many of you are now subject to, you can't count points for days where people are not working because of one of those protected absences. And the New York legislature a couple of years ago made this abundantly clear through an amendment to the labor law's general retaliation statute that says, no, if you count that against someone for discipline purposes, then you're retaliating based on whatever it is, the protected statutory leave, whether it be FMLA, um, paid sick leave in New York, or paid family leave, or what have you. In reality, all of those laws probably already implicitly made that a retaliation claim, or under the FMLA, there's reference to interference claims. Um, so those are a little bit less complicated. If someone's on FMLA leave, they definitely shouldn't be getting points under an attendance system, nor should they just be terminated generally for failing to show up to work, obviously. The more complicated ones become, again, those accommodation leaves where the employee is allowed additional time out of work, even though they don't have a specific statutory day, quote unquote, to cover it. But even those days that are being allowed as an accommodation can't count against the employee in their attendance system. Again, all of these scenarios, you can see how they could interact with each other, and often the proper response is ultimately what we have here in front of us. You should always be ensuring the proper attendance reporting channels are followed, whether it's an FMLA situation, a day off under paid sick leave, or a doctor's appointment in the midday that's covered through your sick leave policy and your collective bargaining agreement. It needs to be documented properly, or a problem could arise down the road. Granted, there are a lot of exempt employees for whom you're not tracking time very carefully on a minute by minute, hour by hour, or even necessarily day by day basis. But it is important to still follow your policies with respect to those employees, because it's possible that if you've allowed an exempt employee just to take off a day every week, to be with their newborn child, for example, without any documentation, you may still be paying them because they're getting a salary anyway. Um, they might still, at some point in time, come and say, now I want my 12 weeks, for example, and you would have a hard time challenging that. But if you've documented each of those days as FMLA, or through paid family leave, again, recognizing that if the employee says, I want to take time off, you can say, this is going to be FMLA, or here's the paid family leave paperwork, or whatever your situation warrants. Regardless, once you get that properly documented, request the proper documentation, get everything categorized properly. If there was some form of protection in the ways we've talked about, or through other policies that allow the employee to take the time off, they can't be penalized generally for taking that time off.